Hi, just a reminder, we will not be having class on Thursday, so there won't be a video posted for Thursday, and we won't have a live class discussion on Thursday. We are in our final big unit for the class, remedies. How do we do damages calculations? What kinds of remedies can buyers and sellers ask for under the UCC? So, a reminder, what are ways in which the buyer can breach the contract? So right now, we're going to start by focusing on what kind of remedies sellers can get under the UCC. So how can the buyer breach? They can wrongfully reject the goods. So the goods are conforming, the buyer still refuses to accept them. They can wrongfully revoke their acceptance. Again, goods are conforming, and for whatever reason the buyer claims that they're not conforming, revokes the acceptance even though the goods are per the contract, so the seller should still be receiving payment for them. Buyer can just fail to pay. You can accept the goods and never make the payment, and the buyer can anticipatorily repudiate. So the buyer can say, I know we have a contract, seller, don't bother sending the goods, I'm not going to pay for them. One thing I want you to be thinking about at a high level as you go through the remedies is that the seller can still pursue one remedy, like reselling the goods to a different buyer, while asking for another remedy, like action for price, forcing the buyer to pay for the goods. The remedies are meant to give the seller, and frankly buyers, a lot of leeway, a lot of different routes to try to mitigate the financial cost to them while still having options to pursue remedies against the other party. So here is a little summary of what kinds of remedies are within the UCC to get sellers that benefit of the bargain. What we might refer to in general contract law is expectation. Right? And all of these are ways of trying to get the seller to the point of they had a contract to complete a deal that the buyer was going to purchase a good and pay them a certain amount of money for it. How do we get sellers back to that point? Well, the most obvious way is the action for price. Simply making the buyer purchase the goods. Buyer, you must give me money for these goods and then take the goods. Why might a seller, I should say, want to do that? To actually just force them to take the goods? Well, goods cost money for sellers to store and care for and watch over. And the seller doesn't want unsold goods sitting on their hands forever. So there is some appeal in trying to just get the buyer to go through with the transaction as was originally contemplated. Now, if that's not happening, if the buyer is refusing to purchase, one thing that the seller can attempt to do is just resell the goods to someone else. And get that difference in price. So presumably this is a situation where the price for the goods has dropped, and so when the seller has to find somebody else to buy them, has to do a resale, the seller's not getting as much money as they would have gotten from the original deal. Similarly, if the seller doesn't sell the goods elsewhere, they can seek to get the market price for the goods. And again, as I just theorized, this is probably a situation where the market price for the goods is lower than the contract price for the goods. So in that situation, the seller doesn't sell the goods, they get the difference between the contract price and the market price, plus, as we'll discuss, incidental damages. As a seller is also entitled to in resale. Finally, the next big type of direct damages, action for price, resale, market price, the last big type of direct damages that sellers can get are lost profits. And we're going to talk about that in the context of advanced sellers remedies, the lost volume seller scenario. Right? But those are, you'll recall from contracts, situations where you have a seller who's doing so much volume that if one of their buyers steps out of line, it's just a pure loss because there's, in theory, this long stream of buyers out there waiting to do the same deal with the seller. In that case, something like resale or market price doesn't make sense. Right? And what the seller seeks is the difference between the cost to produce the good, right, which is going to be pretty low, and then their cost to sell it, which should be higher, right? And that's their lost profits. Right? Sellers can also receive under things like resale and market price, incidental damages. So these we will talk about, but these are amounts of money that the seller has to spend because the buyer breached. So amounts of money that the seller might have to spend storing the goods or finding another seller, for instance. Now, interestingly, consequential damages are generally not available for sellers. It's going to be very different when we're talking about buyers, because buyers do receive consequential damages under the UCC, but sellers typically don't. And it actually makes sense because for sellers, usually what is happening is they just expect to get whatever the profit was going to be on that deal. Whatever the difference between the amount that the sellers had to pay to get the goods and the amount that they're selling them to the buyer for, that's going to be the profit. And so that's the number, right, that the UCC is trying to get the sellers to. Different for buyers very often because buyers are actually in a middleman situation. Right? The buyers are getting goods from sellers, and then those buyers in turn, think about a retailer or some sort of smaller supplier getting from a wholesaler. They expect to then turn around and sell those goods to other people, and they may already be on the hook for contracts to sell those goods. So we'll actually talk a little bit about that this class, just because I think it's helpful to understand some of the dynamics as you go into this. So sellers can get incidental damages, so things like stopping delivery on the goods, transporting the goods, caring for the goods, and then damages related to return or resale of the goods. So getting the goods back from the buyer, reselling those goods to a different buyer. Buyers, in turn, their incidental damages could be things like paying them back for their costs of transporting or caring for goods that are non-conforming, paying for their costs of inspecting goods to find them to be non-conforming, the buyer's costs of, if the seller breach and doesn't get them the goods, the buyer's cost of having to go out and find other goods to purchase. But the buyers also get the consequential damages. So we'll talk more about this in the context of buyers' damages in the next class. But these include economic damages that flow as a consequence of the seller's breach, but then also these personal injuries. And we, of course, know that it's prima facie unconscionable under the UCC to limit consequential damages for personal injuries. We've seen the two cases for today really grapple with notions of mitigation, ultimately. What steps should the seller be taking? What's reasonable to expect sellers to do when buyers breach the agreement? So the first one, Sack v. Lawton, is looking at action for price. There's a fairly complex set of deals involved, but stripping it down, there is an agreement for Lawton to buy this Modello, that's the name of the painting, the nickname of the painting really, by the Italian artist Raphael. And they ultimately don't do that. There's discussion about whether there was going to be a sort of trade of a different painting and how that was all going to play out. But ultimately, the court does find a few things that are really important in favor of the plaintiff here. The first seems to be that the plaintiff did try to mitigate her damages. She showed the work, she displayed it, she tried to find other buyers. Right? The fact that she did that ultimately allows her to succeed on the action for price, and the court notes that plaintiffs have established that under the circumstances they're unable to resell the Modello at a reasonable price. So just keep in mind that the more typical damages for seller are going to be based on resale or market price, and to actually force the sale through an action for price, which is basically the sales equivalent of specific performance, you do typically as a seller need to show that you made an attempt to resell the item. Again, why action for price as opposed to just market price? Well, because for paintings, it's hard to establish the market price. In fact, the evidence that she tried to resell it and couldn't find anybody to pay the same amount suggests that the market price is probably, unascertainable. Right? And that, if anything, it's going to be lower. And that might make it difficult, right, to determine. And so in this situation, because we have such a specific object, we have a concrete agreement to purchase it, she made reasonable efforts to resell it, action for price makes sense. Now, the plaintiff was also asking for consequential damages. She didn't get those. But the court allows that incidental damages might be possible. Things like out-of-pocket expenses, stopping delivery on a painting, getting the painting back, caring for it. Those sort of things might be compensable. But keep in mind, if the plaintiff, as she does, wins here on an action for the price, once she gets the price, she has to give the goods to the buyer. Now, if she doesn't get the price, if even despite this court order she doesn't get the price, she doesn't ever get the money from the buyer, she's not under an obligation to hold it forever. The seller still has the ability to pursue the other remedies like resale, pending receiving the money from the buyer. Then we have our case of Furwood versus General Tire. And this is an interesting case because in some ways it seems like here's an example where the plaintiff seller, that makes something called post-cure inflators for tires, actually tried to do the right thing in terms of mitigating their damages and may have ended up somewhat worse off for it. So General Tire closed down their plant, repudiated their agreement to purchase machinery and equipment from Furwood, and Furwood attempted to resell the machines that it had agreed to build for General Tire, and eventually Furwood did sell all of the machines, but it took 3 years for them to do it, and they had to scavenge some other parts from the machines as they were waiting to be sold and replace them with different parts to actually sell the machines off. Lower court rules in favor of Furwood. The Sixth Circuit reverses on this question of interest, saying that Furwood should only get interest on the trial award, not any prejudgment interest. And the claim essentially by the defendant here is that sellers' remedies should be more limited than they were at trial. So General Tire's basic defense here is that by swapping out parts on this machinery, the machines in question were not the ones in the original contract. They weren't the ones that were identified in the contract between Furwood and General Tire. And because of that, they shouldn't count. That the swapping out parts means that, Furwood, I guess, benefited from being able to use this machinery in some way, and that the subsequent sale of them shouldn't count for resale calculation purposes. The court says what Furwood was doing was substituting fungible parts, and that was okay. So then General Tire says, okay, if we're going to say that these are the same goods, all right, but 3 years was too long to resell these machines. Was that a commercially reasonable amount of time? And the court said, yeah, that actually was a commercially reasonable amount of time under the circumstances, because it seemed as though Furwood was making these efforts in good faith. The district court said that Furwood should be able to collect on its lost use of money during the resale period. Right? This is the pre-judgment interest question. The Sixth Circuit disagrees. They look at how Michigan, the state of Michigan, defines incidental damages. And they say that Michigan has a narrow definition of incidental damages. This is on page 449. And that the kinds of damages that Furwood is arguing for in terms of this interest payment is consequential damages, or at least it would be in Michigan. Now, even if Michigan law were silent on the matter of interest, whether or not that was incidental damages, I think that probably the Sixth Circuit still wouldn't have allowed it, because it favorably cites a Seventh Circuit opinion characterizing the lost use of funds as a consequential damage rather than an incidental. Right, and remember, general default rule is sellers don't get consequential damages. But they do point out seller can get interest on the judgment as of the date of filing the case. All right, so how does that hurt poor Furwood here? Because if Furwood had sued General Tire immediately, they would have started getting interest as of the date they filed, 3 years sooner than when they, in good faith, attempted to resell the machines, mitigate their damages, and then 3 years later sue. So by not acting sooner, it seems as though the seller actually might have lost some money, given that they ultimately did win their suit and established General Tire's liability. Okay, I will see you tomorrow to discuss the problems for assignment 22.